Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now. We are here to solve problems, and we want to make sure that I talk to you about ways to solve problems, especially during these times when people are losing their temporary status here, and so many scary things are happening. We still need to stay the course and focus on solutions. So today I want to talk about ways to be able to get the green card yourself, right? Now, that's what we help our clients to do. It's about empowerment. And yes, there are ways to get the green card for yourself, even in cases where you don't have your papers. You may have overstayed your visa. You may have even come into the country without inspection. But despite that, you still may be able to get your green card. I always say this: we can't help you unless you help yourself. By making the phone call, we right now are working to make sure that we have our office open 24/7 for anybody that needs help. So you can make a move to give us the office a call. They'll do an initial evaluation. And part of the initial evaluation is to see if you qualify for an option like this, where you have a path to obtain permanent residence. Um, so that is the way you're going to be able to personally start to make moves towards a solution. But I'm here to share information that can empower you on this journey, give you information you may not have known about, that can help you to get your papers and get your green card. So let's talk about some of those ways. Put your questions in the comments. By the way, as soon as I'm finished talking about this topic, I'm going to answer some questions. But I think there are many people right now that need to understand this. Now, I am pretty sure that some of you are watching right now and you're in this very frustrating situation where you have a relative who can sponsor you, or a spouse who should be sponsoring you, and they are not. And the main motive for not moving forward is they like the control they have over you. They may use it as leverage. And if they apply for you to get your papers, they no longer have that leverage over you. That can result in you being able to apply for your own papers if they're mistreating you. And certainly, if they are in a position to sponsor you and they are not, because they're using it as leverage against you, certainly that is a form of mistreatment and abuse, and it qualifies you to apply for this first option called VAWA. Now, VAWA, if certain qualifying relatives mistreat you, and mistreatment could be verbal, doesn't have to involve police reports, physical injuries, physical violence. It can be emotional, it can be verbal, it can be extreme cruelty. So the fact that they are refusing to apply for your papers when they know they should be, for example, a spouse, that is an example of extreme cruelty. Your spouse has you here. They will not sponsor you, though, because they want to continue to use that control to keep you where you are, right? Keep you submissive to them, to keep you subdued to their demands. If that is the case, then you can qualify for VAWA. If the person that's doing this is a spouse, a parent, or a U.S. citizen or resident spouse, a spouse, parent, or a child, adult, citizen, child. So let me go over that list again. Qualifying relatives, those who mistreat you. If they are a spouse, a green card holder, or a U.S. citizen spouse. If they are a green card holder or a U.S. citizen parent and you're under the age of 21, or you're under the age of 24 in some cases, you may qualify for this. And then also, if your US citizen son or daughter is mistreating you, they're now age 21 or older, and they were mistreating you even in the past, you can qualify for this. So make a move now, get in touch with us. We can talk to you now about what happened to you, and we brainstorm, go through strategy on how to approach your case. But the important thing is to make that move now. Now is the time. We are getting approvals for our clients who are in the same situation. Since the year has started, we have had multiple approvals, and our clients are walking away with their green card, their 10-year green card through this process. Now, the benefit of this process is that when you apply for this, it means that you can, no matter what happens with that relative, you can move forward with your own green card process by applying for the VAWA petition. And then with the petition, you can apply for adjustment of status at the same time in most cases. Adjustment of status is where you get to stay here in the US and get your green card. So you don't need to leave, and you don't necessarily need to have your papers. If you overstayed, if you ended up coming in without inspection and this is happening to you, you still qualify for this. And this is one of the few categories where they don't look at your entry. They don't look at your current status in order to approve you for the green card. So keep that in mind. Now, I did see some questions coming in that I think are related to this. So I'm just going to quickly answer these questions. So good evening. Hi there, Molten Top. Nice to see you. What about graping or sexual assault? In that case, yes, that definitely does count. Get in touch with us if this happened to you, or if this happened to somebody you know. There may be relief here. So get in touch with us, and let's start with a free initial evaluation. Okay. So the next thing is the T visa. Now, T visa is, once you are approved for a T visa, it means that you can go on to get the green card by yourself. You can self-petition. You don't need anybody to petition for you. If you have been mistreated by an employer, by a relative, by anybody, and in the process of mistreating you, they did that mistreating to be able to get you to do something for them, to work for them, to do acts against your will. They may, even if they didn't mistreat you, say they just lied to you to get you to do something for them that they benefited from. Got you to work in their house, got you to work in their business, got you to do acts against your will, and that doesn't include sexual acts, then you can possibly qualify for the T visa. So it's very important that you understand this option is there, and we can definitely assist you with it. But we need to first talk to you, and right now, we don't want anybody wasting their time and money. There are a lot of scammers out there, and I know scammers are trying to get your money. And what we do to make sure, while we do charge for our services, we want to make sure our services are right for you and that we can succeed for you. So what we have done is we have gone ahead and started free initial evaluations that helps us to determine whether there is an option that we can help you with. Once there's an option that we think you can qualify for, then we move into the strategy phase, where we talk about how we can approach your case to get you to success. But we need you to first give us a call and get started on that initial evaluation. And it's 24/7 a day. We're doing that 24/7 a day. We are filling up very quickly. Our schedule is filling up very quickly. Our attorneys are very busy. So what I would say is, if you want to take action now, and I know you do, then make sure you do that now. Don't wait, because we are filling up very quickly. And in some cases, we can be scheduled weeks out. So please make sure you take action right now. Okay. So for the T visa, what happens is once we determine you qualify, we go ahead and we submit the T visa application. And really, the evidence in both VAWA T visas, it depends on your case. So that's where we need to talk to you. We need to figure out what happened. In some cases, your statement is enough, right? So your statement is enough to be able to get you the approval on this. So don't worry right now about what I have, what I don't have. The important thing is you contact us. We are a safe space. We can advise, we can determine whether this is a case that we can put forward to the USCIS office. And then, from there, we work from there, right? But we need to, so don't worry about everything else. Did you go through it? Did you go through it? Is this something you can relate to? If it is, it's time to give us a call. All right. And then the last one. So, okay, here's another one. I just saw somebody say, is USCIS waiving I-751 interviews? That is relevant to the 10-year green cards. I'm going to go over that. That's another way you can apply for yourself. No, they're not. Well, I would say this, that they do have the ability to waive interviews, but it's very likely most people are going to be scheduled for interviews now for I-751. I-751 is going from the 2-year to the 10-year. And this is also relevant to this topic here, because if you are in a situation where you got your 2-year green card through a spouse, but guess what? Maybe you and the spouse are now separated. It is absolutely essential that you take action right away to go ahead and notify USCIS that you're now separated and you would like to move forward with a waiver to apply for your own 10-year green card. If you don't do this, you will surely be denied. It is, especially if they've filed divorce, right? But you don't want to play it off like you're still with your spouse. You don't want to wait to see if they schedule the interview. Our clients that have found us and that says, listen, I'm separating from my spouse. We're not even divorced yet. This is what happened. They mistreated me and I had to leave the situation. They have been successful because they took proactive steps to understand what their rights are in this process where they're going from the 2-year to the 10-year. How can they get the green card without their spouse involved? And we take action to inform USCIS as soon as possible so USCIS can process it as a case where they're applying on their own. So this is a way to apply on your own without involving the spouse when you're going from a 2-year green card to a 10-year green card. And then the other one is the national interest waiver. So this one is based on your education. So if anybody is coming to you to say, have you applied for the national interest waiver? You can apply for your own green card. You have to be very careful because you do have these scammers and even people that claim to be immigration specialists who push the national interest waiver, but they go ahead and submit an application that does not qualify. And at first, people tend to think, oh my gosh, this is working because they get their work permit while they're applying. But the thing about it is they don't qualify. And now immigration has flagged their case as even possibly fraudulent. So you have to be careful with the national interest waiver. Make sure you're qualified. In the case of the national interest waiver, here's the deal. You must be, the green card is based on you having an advanced degree or you having a bachelor's degree with 5 years of experience in your field, or you can have exceptional ability, but you have to meet 3 out of 6 specific criteria for that to show that you have exceptional ability. Advanced degree means your master's degree or your PhD. And then, of course, the bachelor's degree, but you also have to show your 5 years of experience in your field. Once you've met that, once you've met that standard, then it's not over yet, right? So don't let anybody just say, oh, you have your advanced degree, automatically you get your green card. The next step is you do have to put stress on what your goals here are in the US, right? That's very important in this application, your goals and your experience. So you do have to have a goal of national importance and substantial merit. I always say this, it doesn't mean you have to be famous, doesn't mean you have to invent anything, but it does mean that whatever goal you have, it's going to basically benefit the United States in a big way, right? It may fill a shortage in certain industries. It may develop certain industries like technological industries. For example, AI. AI, the development of AI is really big right now. That's a focus, it's advancing very quickly. If you have experience in the tech industry based on your advanced degree or your exceptional ability, and your goal is to come here to contribute to the development of the AI in certain spaces, that could definitely fall within an arena of a goal of national importance and substantial merit, right? So that's the first thing. Say that's your forte right now, is you want to come here to really get involved in AI. Maybe you want to even have a startup company where you're focusing on AI in certain industries. That's the first prong. Second prong, do you have the means to achieve this? So this is where experience is going to be very important. What's your track record? Are you running a company in your own country that has done very well, that has a good track record in the AI industry or technological advancement? That's going to be a plus. Have you worked with any other companies that have been in that arena and they have made great advances and you have contributed to those great advances? That is going to come here. And you're going to show that through letters of recommendation, character letters. You're going to show that through showing maybe awards that you've gotten or accolades that you've gotten. You're going to show it through numbers. In what ways did you contribute to that industry? That is going to show the immigration officers that you do have the means to achieve the very important goal of advancing AI here in the United States. Then the last one is it more advantageous to the United States to just give you the green card rather than requiring an employer to sponsor you, right? So basically, why should the US, you need to answer this question. Why should the US give you the green card rather than just letting an employer sponsor you to achieve these goals? And that is going to be very dependent on the type of industry. So for example, AI is really it's developing at a very fast rate. And because of that, maybe there's no time to go through an employer sponsorship because you have to get to work right away in order to continue to contribute to the advancement of AI. So that could be a possible basis. I mean, there are multiple arguments, and this is just a scenario that I'm giving you a brief view of how we would approach an application like this. Now, once we meet those prongs, then we would go ahead and submit the petition to USCIS. And keep in mind, if you're here in the US, here's very important fact here. Now, I've had many people say, I'm out of status. They have the education, they have the goals in mind, but they may be out of status. If you're out of status, then it's going to be a lot more complicated, and the likelihood of succeeding to get to the green card, it goes down, right? And that's where it's very important to make sure that you do a consultation first to evaluate. There is here, we start with the petition right now. We also have to look at the National Visa Bulletin to see when you can apply for adjustment of status. The thing about it is you have to apply for adjustment of status when you are in status. So if you've overstayed, you're not going to be allowed to stay here and get your green card. So it's very important that you maintain your legal status. So say you're here on an H-1B, you're here on a current visa, you're maybe even here on a student visa, but you have the credentials. Even though you're here on a student visa, you have the credentials to get you to the national interest waiver. Then it's important that you maintain your status, because if you fall out of status, you may be able to apply for the petition and even get approved for the petition. But I think the most surprising part for people is that you realize that you won't qualify for adjustment of status because you overstayed. So you must maintain your status, or you must follow the National Visa Bulletin to know, do I have to go back to my country to do consular processing? Because there's no way I can maintain my status while going through the petition process. The advantage of the national interest waiver is you don't even necessarily need to have a job offer. You can, but at the same time, it could be your goal is to start have a startup company, right? Where you are building a company to put forth your goals for AI. This is an example here. AI is just an example, but you don't need a job offer, but you still do need to back it up with other evidence. And you don't need to go through a labor certification process, but you do need to meet those 3 prongs. So the national interest waiver is a way to apply for yourself. There's also the investor's visa. So if you invest, right now it's still the same. If you invest 900,000 or 500,000, if it's through a certain, if you do it through a certain avenue, then you would be able to get what's called an EB-5 green card. So it's a business investor, sort of like passive investment. You put the money into a business here in the United States, you beat at least the minimum for the investment, and then in return, you get the green card. So that's also one way to sponsor yourself. So, think about these options. If you can relate to any of them, then it's time to give the office a call, schedule an appointment. Also, U visa. But the reason I'm putting the U visa as the last thing is because the U visa right now, it's taking about 10 years just to get 7 to 10 years just to get to the U visa. Then you can go out and apply for your own green card. So it is a long road, but if it's the last resort, if it's the only option you have, then you need to consider it. The one other benefit of these, by the way, is while you're in the process of applying for your own green card and you're here in the United States, you can get certain benefits like your work permit. So you're able to work, have your social security number, get the real ID, travel, and even a travel document in some cases to be able to stay here and wait for your green card, all without involving a third party. In the cases where you're doing this, you're applying for this because somebody else won't apply for you, they're mistreating you, it's confidential. I mean, all of these processes are confidential to a certain extent, but when it comes to VAWA, the T visa, U visa, asylum, by the way, is another one we'll talk about. But with all of these, you're able to do this in a confidential setting where you don't have to worry about that person who was doing the mistreating or the person that victimized you finding out and retaliating against you. That's a very important, it's written in the books. And because of that, immigration does not communicate with third parties about your case. Another benefit, for example, with VAWA, is that VAWA, this is where a relative is mistreating you, is that when they're making the decision, if, say, the relative calls to sabotage your process, they cannot take their any unsubstantiated information from them. So if they're telling lies, they're just telling them immigration stuff. Because you're in this process of VAWA, they cannot take that information and use it as part of the decision making process. So that's another important protection that you have. And the reason it's important is because oftentimes when you do not have the protective process of VAWA, an abusive relative can always sabotage you. They can sabotage your immigration status. They can call and tell lies. And at that point, immigration can take that as a tip. But when you have VAWA, there's an extra layer of protection there that the officers have to consider the fact that you are the victim and that they cannot make any decisions based on something that is not substantiated. So it cannot be proven. They're not backing it up with evidence. They cannot use that information against you. All right, so I leave it to you to go ahead and make sure that you give us a call. So we start with that initial evaluation. Then the attorneys here at the law firm that I work very closely with will be able to talk to you and get started on your process. But we need to make sure that you take that step first. So take the step. We're a safe space and we can talk to you about your options after we determine that there is something. So asylum. So that is the other one. Asylum is another way to get to the green card on your own. Now, at this time, it has hit the news that those asylees and refugees who are applying for the green card, that is on pause. But keep in mind, it's on pause. It's written in the books that asylees and refugees who obtain this asylee status or refugee status can apply for their green card. So they cannot take it away. They cannot stop it altogether. They have said that they are doing a pause on it. And I'm pretty sure that we're going to see, if we haven't already seen, lawsuits and challenges to that. Because it is law that this needs to be done. 1 year after getting refugee status or asylee status, you can apply for your green card on your own. So that's also an option to move forward. What's asylum? Asylum is if you are afraid to go back to your country because you are being targeted or threatened based on certain categories so I like to say this, based on your identity. An identity you cannot change. For example, based on your sexual orientation, based on your religion, based on your political opinion, based on your family ties, things that create a certain identity that puts you in a particular social group can get you asylum, right? Meaning you can't go back to your country because you're facing threats based on those characteristics that you have, those unchangeable characteristics, or it's not necessarily unchangeable, but for example, your political opinion. If you put your political opinion out there publicly and they are always connecting you to that public opinion, and then they start to target you, threaten you because of that, then that can get you asylum. If, for example, you are part of a particular social group that is fighting against gang violence, can be considered a political opinion, and you're facing retaliation, and the government is not protecting you. Now you're facing threats from the gang people that you're opposing. Then that is possibly asylum based on political opinion and in some cases particular social group, just depending on your specific facts. So once again, the step is to get started. Asylum, though, you must apply for this within 1 year of your entry or where circumstances have changed. So for example, unfortunately, many immigrants are facing they are facing termination of TPS. Venezuelans are looking at this right now. Haitians are looking at this. The Supreme Court just said that the president can't do this. Now, seeing that the Supreme Court has said this, we know for sure that Venezuelans and those on TPS are in real danger of losing their status and then being subjected to removal. Well, asylum, because TPS is there to keep them protected from going back to a country that's unstable where they may face persecution, violence, just depending on what's going on in the country. Well, in this case, there may be an argument here for changed circumstances. Now that they don't have temporary protected status and they can't go back to their country, asylum could be a real option here. Asylum could also be an alternate defense for removal. There's also alternatives to asylum, like withholding of removal and CAT protections, Convention Against Torture, which protects people from going back to countries where they will be tortured or killed or vulnerable to violence. And it's more likely that they're going to face those things. So if you can relate to something like this, I say take action now. Look at your options. It's so important because things are changing and you want to make sure you put yourself in a more permanent position, protective status, like getting your green card or taking the steps to get the kind of status that can lead you to the green card. The downside of this, now, what I want people to know is that TPS is a discretionary benefit. So I did have, I knew that the Supreme Court was going to likely say that the president can because it's a discretionary form of relief. But keep in mind, statuses that lead to the green card, these are written in law. They are statutes that the government, the president cannot just take away. And that is why it's important to evaluate those options. And that's what we focus on here at the law firm. We focus on ways for you to get permanent residence here in the US. Despite, if you're, no matter what situation you're in, how can you get to the green card? Because then we know that you're in a more permanent position. All right, so I'm going to answer questions because I see a ton of questions coming in. Put your questions in the comments now so that I can scroll through and get to them very quickly. How long will my process take? I arrived with a visa and I overstayed. My husband is American. So it could take, right now, I would say 10 months to 12 months to 1.5 years. Right. Things are getting longer because they are looking at, so they're making the process longer because they're taking steps like looking at your social media now. They're going through extra fraud detection and they're scheduling interviews again. And all of those are last Trump 1.0. I practiced during that time and processing times went as long as 1.5 years to even 2 years because of the extra processes that were put in place. So we can see that again. Can you file N-400 after having green card as asylee for 3 years and being married for a U.S. citizen? Yes. So if you're married, if you had the green card for 3 years and you've been married to your U.S. citizen spouse for 3 years, then you can apply for 10:12 p.m. You can apply for it early. Thanks for sharing the live. Thanks for the love. As always, it's so important for others to understand that this information is here, that I am a resource for information that can empower individuals through their immigration journey. So go ahead, tap the screen on TikTok, share, like, subscribe, because that's how people know that that I am here to give this information. And I'm here every day, Mondays through Fridays. I aim to be here Mondays through Fridays. So go ahead, share this information, share videos, make sure you're sharing videos so that people can get this information. A lot of people don't know that there are options there to empower them. And guys, we are seeing it. We are seeing results. We are seeing approvals coming in. So it has not stopped, but it's really a matter of you understanding what your options are. Okay, so hello, I'm a green card holder. Can travel to my country in Afghanistan? So I would say this. I am looking at whether or not my clients can travel on a case by case basis with an overall approach of being very conservative on travel. You're a green card holder, so you're able to travel, but there are certain risks once they do implement a travel ban, and I think Afghanistan is going to be on the travel ban when once they announce it officially. You want to be careful about traveling back to a country that is on the travel ban. You may face additional scrutiny coming back into the country, even as a green card holder. So just be very careful. And then, I continue to see headlines talking about green card holders being detained at the airport based on something they find in their background. So if you're really concerned about anything, you need to talk to your lawyer about traveling before you actually make the move to travel. How long does marriage-based green card take if married to a U.S. citizen while both in the U.S.? So I would say 10 months to a year and a half right now. And you can expect an interview to be scheduled now before they make a decision. Thanks for sharing the live. Thanks for the follow. I've been 2 years filed for FAWA. I had 3 prima facie now. How long should I wait for a decision? Now, keep in mind that I don't control processing times. I can only talk about my own experiences and my clients' experiences. And I would say the processing time is 2.5 to 3 years to get a decision. And then after that, about 6 months to another year to get to the green card. Now, I know many people might be saying, oh my gosh, that takes a long time. I'll rather rough it out in the situation I'm in, right? And your situation may not be the best. You may not be with a spouse that is treating you well, and you may not even trust that spouse. And this is what I want to give you. I want to give you food for thought in situations like this, that for my clients, it has been well worth the journey, because while they were waiting for their process, they got their work permits, they got peace of mind, they didn't have somebody holding their immigration status over their head, they did not have to stress that their spouse was going to sabotage their process. They were able to go through this in a more relaxed, peaceful state of mind, knowing that they had more security and protection going through the process. So it was well worth it for them. It really was a source of stability for them. So yes, the journey can be a little longer than the marriage base. But here's the deal. If you're in a situation where you know you qualify for FAWA, but you're trying to decide stick it out with the person that's mistreating you or go through the FAWA process, that person who's mistreating you, if you don't 100% trust them to go through the process, follow your gut, because they can sabotage your process and completely cut you off from the green card. I've seen it. I've seen them, those spouses, when I've seen them sabotage people to the point where they permanently bar them from getting the green card by telling lies on them that they only married for the green card, right? Just to sabotage them, because as a US citizen, they have nothing to lose. They're citizens. So keep that in mind. I'm waiting for a green card more than 1 year as a asylee. What can I do? So at this time, they have announced that they're putting it on pause to go backwards, and and evaluate for, I guess, screen for fraud. So we can expect much longer wait periods for that one. I've been 2 years filed for VAWA, so I answered that. When is an I-8, I'm not sure, filed after I-1? So I think this is when is an I-864, the affidavit of support form, filed after the I-130? So I-130 first, if you're outside of the U.S. If you're in the U.S. with your U.S. citizen spouse, then you file, or you're the spouse of a green card holder and you do qualify for adjustment of status, then that I-864, along with adjustment of status, will be filed with the I-130. If you're outside of the US, that I-864 is going to be filed with the National Visa Center upon approval of the I-130, and you'll definitely get notification of it. They'll send you a checklist of what they need. Now, what I would say is get assistance. If you are going through the process, make sure you get assistance, because mistakes can lead to 6 months delays at a time. Each mistake, each very tiny mistake. I've been 2 years, so I answered that already. I'm looking for more questions. So I see the same questions over and over, so I'm just looking for a new one. I have DACA and did AP already. My son will be 21 soon. How long will it take for him to adjust my status? As soon as he turns 21, the day after he turns 21, you can file. Get in touch with us. We would love to help you with this to make sure that you do have a smooth process. So get in touch with us, do the initial evaluation, and then we can talk about strategy from there. How long does marriage-based green card take if married to a U.S. citizen? So I say expect up to a year and a half now. Okay. Thank you for the love. I appreciate it. Can you receive work permit without interview? I'm in adjustment of status, but work permit, yes. So the work permit comes before an interview. It definitely comes, and it depends on what kind of adjustment of status you're going through, but it can range from 3 months. We just got one in 2 months. The shortest I've gotten is even 2 weeks, but it can take even up to 12 months, depending on the case type. Okay, so my wife win her asylum case, grant for, and petition me for more than 2 months. So it's everything is taking time. So even though she petitioned for you 2 months ago, it keep in mind it takes time. How long does it take to get a visa if my church sponsor me? So it depends on where you are. So this is usually called the R visa, and if you're outside of the U.S., it may take a certain amount of time, a few months, depending on the embassy. If you're in the United States, change of statuses can take a while, and that can be frustrating, especially if you have to be maintaining your status. You can be looking at anywhere from a few months or 4 months to even up to a year when it comes to change of status. Usually, though, when you apply for the change of status, if you are approved, they don't hold the time that you've been here against you if you've been approved. So that's the other thing. And you also have to look at an extension. to make sure you're not overstaying. Thank you. Thanks so much for the gifts. I appreciate it. How long does it take for a perm application to be approved? So, DOL, you're looking at 6 months. So, first you do wage determination process through a labor certification process. That takes 6 months and can even take up to 18 months. I've been seeing it even trending up to 2 years. So, it's crazy right now, but I would say shortest 6 months to 18 months. And then after that is approved, then you file a petition. And the petition with the USCIS could take anywhere from 4 months. And it also depends on whether premium processing, if you apply, you submit premium processing, which means that it should be expedited. So 2 weeks, but if they issue a request for evidence, that can make it longer. But the petition can take anywhere from 4 months to a year for approval. And then adjustment of status is processed at the same time if you're in the US. If you're approved for the petition, then it's sent to the embassy and then they process your visa to come to the United States to get your green card. Now, the perm application, what this question is asking is employment-based green card. So it's for employment-based green card. The employer has to sponsor you for this one too. Do I need supplement B for a T visa? It's not required, but it is something that you if you get it, it's good. It's like a cherry on top, but it is not required. I've been to, let me see. Where are you located? We're in Delray Beach, Florida, but we do represent clients in all 50 states and the globe. So no matter where you are, we can help, and we're very good at that. Is USCIS waiving I-751 interviews? They do have the right to waive, but I am going to tell you right now, expect an interview. My husband is in the hospital and he is in isolation. We have interview coming up. I'm so sorry that that's happening. Now, there are two ways to approach this. One is that you can contact them to delay the interview and then to have the interview rescheduled. But if your husband is in a situation that you don't anticipate he is going to recover enough to go to an interview, then really it is to explain that to immigration, to go in to explain that to immigration, have evidence of the hospitalization, the severity of his condition, have a doctor's letter detailing the fact that he can't be present, and make sure you amp up proof of your bona fide marriage, right? So you definitely have to make sure you're walking in there with solid proof that you do have a real marriage with your spouse. Because if you don't, then they will still deny it. So you can look at those. If your spouse is in a situation where you think that they will recover in a few weeks, then, rescheduling the interview could be a possibility. But if not, make sure you are really thinking about the evidence you're walking into that interview with. And proof of the seriousness of the illness, the fact that he cannot participate in the process at this time. And, I would say get an attorney involved because you may need to have further advocacy because if they raise additional questions about the process. So for one, competency may be a question here. How severe is your spouse right now? And how is this going to affect your marriage going forward? So just make sure that you also seek legal counsel to look out for you if further questions arise. But the I-130 was approved with only my husband's name. Is that okay? So I'm not sure. I see. Okay. I hyphenated my last name after marriage. So, it's a matter of what your preference is. If you hyphenated your name, you would rather have your hyphenated name on the green card. You can let them know that they need to correct the name on your green card, if that's a preference for you. But if you are okay with using just your spouse's last name and that is also matches your, identity documents, or you're willing to change your name, that can work too. So it just depends on your preference. I did my 2024 taxes. Is my I-360 I-485 in good shape? So they don't look at your income for VAWA. That's another benefit, is that they're not going to hold, you don't have to prove you make a certain amount to be able to get this. Any information on outcomes of N336 appeals? So it's really on a case by case basis. I would say this. In some cases, so we have one, the N336. So the N336 is if you're denied citizenship. And I had this case that was, it was a game changer for my client. So in this case, my client had been in the military, and they ended up their parent ended up very sick, and they ended up leaving on leave to go take care of their parent from the military. They did not return at the time that they were told to return, and that can be very serious in the military. But they did not charge him with abandonment. They discharged him dishonorably, and that was the end of it. But when he went for citizenship, he was told he was permanently barred from getting citizenship because he had, there's a certain term for it that I cannot remember right now, but it's similar to abandoning the military, right? You go AWOL, but it's more serious than even AWOL. You go AWOL, then they charge you with basically abandoning the military. So he was at a point where he was facing permanent bar from citizenship. And, of course, he came to me, and we read the regulations very closely. And in order for that permanent bar to be applied, it has to be a charge. He has to be court-martialed and convicted for abandoning the military. And he was not. That was not the case. The military decided, as a matter of fact, they were not going to charge under his particular circumstances. And because of that, we won the appeal. So that there was a game changer for my client. And it really does on a case, because this is very, very specific to the facts. It was very specific to the facts. My client in this case had mitigating factors. The military had considered those mitigating factors, that there was a very sick parent involved in what happened. And because of that, my client was able to move forward with the citizenship. And it had the number of years for good moral character had been passed already, right? Which is usually 5 years. So it really comes down to the facts. Why was your application denied, and was there an error in the law that caused the denial that the officer can reconsider? So that's where you definitely need to make sure you do a consultation, and you only have a certain amount of time to file this. So you have to be quick on your feet and understand, is this something you can win? Do you have a possibility of prevailing here? And get started. So Trump put all programs on hold. Not true. That's absolutely false. We are getting approvals, work permits, so they are processing them. So don't believe those. I went for married interview in NJ, now been 84 days, still nothing. So they may be reviewing your case file, going through extra background checks. That is definitely something that it can be happening. Once it gets to about 120 days, you can put in an inquiry to see what's taking so long with that decision, whether they've issued you a request for evidence. All right. So I'm really trying to get through all the questions here. Thank you for your patience on Instagram and YouTube, Facebook. Thank you. I'm going to go ahead and I'm going to answer questions on YouTube, Facebook, and then I'm going to join my friends here on Instagram. So please put your questions in the comments. I can just scroll through and get to your questions. I got my 10-year green card in 2022. Marriage has broken down since. However, my in laws are threatening to contact immigration. Should I be worried? The marriage was in good faith. I'm still not divorced. I'm so sorry that's happening. That's definitely stressful. At this time, I would say 10-year green card. There is really no action to be taken other than to apply for citizenship. So if you're still married to your spouse but you're separated, so it sounds like you're separated, you may be separated, you have to wait 5 years until you can apply for your citizenship. What I would say is keep evidence. Make sure you are gathering, look out for yourself just in case. Gather all the evidence showing that your marriage was in good faith and continues to be in good faith, even though you're not on good terms. Go ahead and make sure you're gathering financial statements, mail that shows that joint bills, mortgage if you have mortgage, cars that you purchase, just anything that shows that you have or were living like as a married couple. You need to make sure that you are gathering just in case they call immigration, and if immigration does reopen your case, because that could be a real possibility. It's rare, but it is a possibility, especially if your in-laws are threatening. They could try to report you for fraud to immigration, and in these times they can open up an investigation. So it's important that you just make sure you have all the information to show that you got married in good faith. So those accusations won't stick if needed. Hopefully you don't need it. Especially if you're applying for citizenship, you want to make sure you maintain, because if there are any questions about that during the citizenship process, you want to make sure you have good evidence to show. My mom has an administratively closed case 1996 and has combo card 2024. Can she travel to Mexico under AOS? Now, I'm not your attorney. I can't give you a particular legal advice, but here's what's happening now. Her case was administratively closed in 1996. So that may not apply to what's happening now, where previously administratively closed cases are being reopened. Yours may not fall under that. I think they're mainly focusing on those that were closed during the Biden administration. But it means that there's an extra element or factor in your mom's background that can complicate her re-entry into the country. So I would be very careful about traveling. I don't know all your facts and I'm not your attorney, but I have been taking that approach generally, that you should be very conservative about traveling at this time. Make sure you're consulting with your attorney. South Sudan passports were revoked in April. Does it mean you cannot travel with the US using real ID and other valid? So I'm not sure what you mean by South Sudan passports were revoked. I think, okay, so in April, they had said that they're revoking visas. So I believe it's all the visas that have been issued to South Sudanese individuals. So if your status has been revoked by the government, be very careful, because if it's revoked and it's revoked effective immediately, you are means you don't have status anymore. So you have to be careful. And the real ID, keep in mind that in the background, if you don't have status, they can also update the driver's license to state that you no longer have status. Uh, so be careful. Definitely get legal advice about traveling, because I'm not your attorney. I don't know all your facts. So that's where but you have to be careful. I have abusive husband, and I don't know what to do. Especially I have a daughter too. I can't get lawyer too because I don't have money and my husband doesn't provide me anything. I'm so sorry you're going through that. So there are pro bono organizations and organizations that can assist. So if you look up a local legal aid, then number one thing is make sure you're safe. If you can also try to, in this time, figure out an exit plan. If an exit plan may be to call a domestic violence shelter that can help you, and if you're not in a situation where you have to escape immediately, contact them to see if they offer resources to help you to with an exit plan. In the meantime, also, there are legal aid societies that do pro bono. So if you have absolutely no money, they can then refer you to an attorney that can do these for free, or for a very, very low cost than what a normal attorney would cost. You look for these in your area and then safely try to contact these organizations to see if they're able to assist you. Just depending on your state, your town, your city. So that would be what I would say, because if they're abusive, they're abusive and you do not have your papers, you can definitely get your legal status on your own and be safe, but you need the assistance to do that. So and with little resources, I would say start there. Okay, so my wife came on K1 visa 8/30/2024. We married and filed I-485 within 90 days. Not a lot of marital evidence at time of filing. We have been uploading evidence on the portal. Will the officer look at it? Yes, it's likely they will get that information, just as long as you're not uploading it the day before, you've been uploading it over time. When they're ready to review it, they should be able to get it. Just make sure you have it on you as well. Have it in a safe space so you can take it to the interview. In case they don't get it, you can present it to the officer at the interview if you're scheduled for the interview. I married a U.S. citizen while on F1 visa, but had to return home due to my dad's health. Can I apply for a green card from abroad? How long does it take? And does my wife need to attend an interview in the US? Yes, absolutely. So it's just consular processing. It does take about 2 years to get through that process. So I would say plan for about 2 years. And your spouse, unless the embassy tells your spouse to attend the interview, you she they're not usually required. It's optional for them to attend, but sometimes they'll get a letter saying they must attend at the embassy, the interview at the embassy. So it depends though on the country, what's going on, and whether the embassy specifically requests your spouse to be there. Can I apply for T visa abroad? I was on F1 visa, victim of labor trafficking. I have a solid case. The downside with the T visa is that you must show that you continue to be in the United States on account of the trafficking. So it means you continue to be in the United States even after the trafficking. So leaving does affect your ability to apply. Now, if you left and then you returned, and you can still show that your return is in some way related to the trafficking or related to seeking help for the trafficking, then you still may be able to qualify. What I would say here is don't count yourself out just based on this. We need to talk to you in a consultation, get all the facts to be able to determine whether this can work for you. I'm separated, and the in laws that threatening to contact immigration was the one who had written an affidavit letter in the first stages of I-130 application following up on the above question. Then just continue to gather evidence other than your parents' letters, your in-laws' letters stating and showing that you have a bona fide marriage. I would say just right now, focus on documenting everything. Document your marriage to show that you do have a bona fide marriage. Had a green card interview this month. After interview, I get a white paper. Should I be worried? I guess it, so they do send white papers. Most of the papers are white papers. So yeah, the green paper definitely means some sort of approval. So I get you on that. White paper can be request for evidence. So I would say, I don't know how come you can't read it, but it's important to read it now to see what's on it. But it may mean that they're requesting additional information. It may mean a denial, but you have to go ahead and look and just see what exactly they're asking for. And some of these are time, there's a deadline, so make sure you're on top of that. Can I provide my employment details even if I don't have work rights and paying taxes for 5 years? Does it help for T visa case? So paying taxes alone doesn't help. Um, Paying taxes, it means you're complying with laws here in the US. It means that it means you're complying with the laws. It means you can show your presence. Sometimes it can show the connection with the trafficker, but taxes in itself is not going to get you the TV. T visa is not based on have you been, do you have good moral character? Have you been paying your taxes? T visa is based on what did you go through. So it's not going to fix it for you. It can, it can just show that you are compliant with the laws and what I said before. So now with the T visa, if you've worked without a permit, it's not going to be used against you for the T visa because remember, being trafficked mean you are forced in a situation that now that whether or not you had rights to work kind of takes a backseat because it's now focused on the fact that you were victimized. So it's not held against you, but you do have to make sure you're truthful about it. How long does it take to get a green card when applying through T status that was already approved? So I would say 2 years right now, a year and a half to 2 years. Work permit pending more than 9 months. What can I do? It depends on what's happening. If it's outside of processing times, you may request, give them a little nudge to say, hey, it's outside of processing times. If you have an emergency, maybe get it expedited. But you might very well be within processing times. I married a US citizen while on an F1 visa, but had to return home due to my dad's health. Okay, so I answered that. All right, so now I'm on who can apply for NIW? Do you have to be in status? Yeah, for the most part, you have to be in status unless you qualify for one of those limited exceptions. What times are calls allowed? Anytime. Call 24/7. You can call right now and you will get an answer and they will go ahead and help you with the evaluation. Hello, I have a brother who won DV lottery. He played as single, then he got married in January in 2025. Can he add his spouse to the 260? That yes, that should be allowed. How long is taking to get our work permit under this administration? Right now, I would say 6 to 12 months still. So we haven't seen much of a change. Um, All right, I'm on Instagram and then I'm going to have to head out for the night, but I will be back. I really enjoy answering your questions. So I'll definitely be back tomorrow. Like, subscribe, follow, share. This is how people get information that empowers them through this journey, but also that also helps you to know when I'm on because you'll get notification if you follow that I'm live, and then you can join me if you're available. So, because I tend to be on sometimes just depending on how busy the day is. Okay, so let's go on to Instagram now. I'm going to answer here. What if someone didn't follow through on their asylum case, got deportation letter, and they didn't go now? They're trying to marry a citizen. This is a very complex case. Once you have an order of deportation, you have to go back to the court to see if you can get it reopened and terminated, and then get it within the jurisdiction of the USCIS again. So definitely get in touch with us. Let's talk about the complexity of your case and figure out a strategy moving forward. No, here's another very disturbing thing that's happening is people are getting fined. So I've been seeing multiple of my colleagues getting clients are getting fined up to $1.8 million for being here after they got removal order. So it basically accrues over time. I believe $1,000 a day. I believe I'd have to check again to see, but I believe it's $1,000 a day for every day after they were supposed to leave that they didn't, up to $1.8 million. They are issuing these. Now, it presents an additional complexity because now with a fine like that, it would be very difficult to fix your immigration, right? Because if you're unable to pay the fine, then it means that it can lead to a lot more legal problems. So that is also happening. It's very important to make sure that you get legal advice about your options. And if you get a letter like that, you definitely need to be proactive on it because they are looking at taking away property to cover the expense for that. So, working on a store yesterday, a guy came and threatened me to shoot down, and police came, arrested that guy. But no, my owner is not giving me the recording of the incident. Do I apply for the U visa? So give us a call. There is a possibility that you could qualify, but we need more facts. Did you give a police report? Is there a police report out there? No, the police did arrest them, which means that the police did take it very seriously. So are you cooperating with the police? As in, did you give them the report? Did you give them the statement? So definitely give us a call. Let's talk about what you went through, and then we can move forward with a strategy. But now is the time to do that for sure. I know someone who got deportation letter and they're still here, got kids now, and it's SN issue to get their passport. I don't know what that means, SN issue. And it is an issue. So, and now it is an issue to get their passport. Oh, wow. Exactly. Those kids are US citizens if they were born here. And I don't know why they would be having an issue because the Supreme Court has not issued any order saying that the president can terminate birthright citizenship with an executive order. And I think it's absurd if they ever do that because an executive order cannot override a constitutional right that if you're born here, you are a US citizen. So, they may be having, it may be an administrative issue. They may be having maybe there are mistakes on the application that's causing a delay on the passport application. But you definitely need to seek legal advice about that to determine what's going on with that. Because if they're born here, they should be able to get the passport. I'm on F1 visa, and my wife and one kid on F2. They visited us. They visited US, went back to India. I have two more kids tried for the F2 visa 4 times, but it's getting refused. Any advice? So it depends on the reason for the denial. I don't know why they were denied, but it could be their ties to the country. So they would have to strengthen their ties to show that they will return to their country if they're given the F visas to go to the country. I applied for my green card application on March 2023 with approval 360. That's a VAWA. They asked me evidence on October 2024. I submitted it. So how long you think they're going to take to approve my green card application? So it depends on what kind of evidence they ask and what you submitted. If they accepted that and they approve it, we were seeing anywhere from 4 months to 12 months to be able to get the green card after the VAWA approval. I'm currently holding J1 visa. Is there any opportunity for me to extend it? So it depends. It depends on what your particular category is with the J1, and then if that's allowed. It may be allowed, but you do need to have your sponsor do it. You may have 2-year foreign residency requirement that may hinder that as well. My green card rescheduled was approved, but they still denied my I-4. So my green card rescheduled was approved, but they still denied I-45, I-130 on the day of the interview. Yes, and that is one of the things that is frustrating, is that you may have gotten it rescheduled, but yet there is a mistake in the system. So that really is going to go towards reopening your case, and that has to be done ASAP. So you definitely need to look into that. So there are certain motions to reopen that you have to look at doing, and that you have to look at that within 30 days. I have a green card since 1989, but I lost it in 2006. Should I apply for a new green card? I'm also married to a US citizen. Should I start a new process, or can I just apply for citizenship? Get in touch with us. What I would say here is no, you are a green card holder. Unless you went through removal, a judge took away your green card, you are a green card holder, even though you lost your green card. So in this case, if you need a replacement card, you need to apply for it through the I-90 form. And yes, why not apply for US citizenship? But please make sure that you talk to us. You can call, schedule an initial evaluation. Then we will talk to you about whether you qualify, or is there anything that you're worried about. We can address your concerns regarding applying for US citizenship and move forward with a strategy. But it sounds like you may have some options here. But the good news is, based on just this general information, keep in mind, I'm not your attorney. I can't give you personalized legal advice. But based on this general information, just losing your green card does not mean you're no longer a green card. So if I am right on these facts, you should not be applying for a green card all over again. All you have to do is get your replacement, but also get your citizenship. How long does it take NVC to process for siblings? 14 years minimum. So it's a long time. Can someone who came in through the border and under pending asylum change status through marriage to a US citizen? It depends on when you came in. Did you get paroled? If you were paroled, possibly, if you have the right type of parole. So very important you talk to an attorney. You can always give us a call and we'll talk. The day before my interview, USCIS approved my reschedule, and on the day of the interview, they denied my case. I'm so sorry, and that is common, these kind of misunderstandings. I need a work permit. How can I get it? Multiple ways, but we need to talk to you. That's why we have the free initial evaluation. If you're thinking about taking action now, maybe this is the only time you have, get in touch with us, do the free initial evaluation, and then we'll be able to talk to you about your options going forward. I filed for my wife and stepdaughter and was accepted, but I didn't hear anything about it. What can I do? Wife lives in Jamaica. So I-130, if you file I-130, then you have to wait for that to be approved. Once that's approved, they're going to send it to the National Visa Center. Then the National Visa Center is going to go ahead and process the documents and schedule your interview. You can expect about a 2-year process in Jamaica, 1.5 to 2 years. All right, that's going to be, so I want to invite my wife and to the US. So you can, but keep in mind that your wife still has to show that she has strong ties to her own country before she's issued a visa. If you want to apply for your wife's green card, that you can definitely do. You can get in touch with us. We can help you get started ASAP. F3 immigrant visa, not current in final action date. Do I have to wait for that chart to be current to apply for expedite? It's likely. The expedite is not going to happen. They're not going to make you skip years ahead. It really has to be compelling in order to get that done. So you likely have to wait. My father was a citizen, applied for permanent residence for me, and I had approved since 2019, but I was waiting for the embassy to call me for an interview since I'm in the state. Hello, my father, who was a citizen, applied for permanent residence for me. I had approved since 2019, but I was waiting for the embassy to call me for an interview since I'm in the state. So this is where it's very important to make sure that your priority date is current before you apply for adjustment of status. So if you're here in the States, you need to maintain your legal status until you know that it's time to apply for adjustment of status. Thank you so much. I see you. Is your case, so I think somebody's talking. Let's see. Good night. First time watching. If F2B category, welcome. If F2B category receives NVC welcome letter and follow the instructions and create an online account success, how long before NVC update the applicant or petitioner? You're at the time that your priority date is about to be current, then they'll go ahead and contact you, and then you follow their instructions. How long is it taking to get receipt notice? Right now, we're seeing it taking much longer. We're seeing 2 weeks to 12 weeks to get the receipt notice. So things are moving a little slower. My employer said to my coworker that he will sponsor me, and the coworker employer is just giving false promise. I have video footage of him saying to the employee about the sponsorship, I'm on F1. I'm so sorry, but that can qualify you for the T visa. If you made a decision to work for them because of that promise of sponsorship, and now you realize it was false, they never meant to do that, then that is trafficking by fraud. Because if you would have never agreed to do that, but then this promise made you work for them, then that could be labor trafficking by fraud. And it qualifies for the T. Labor trafficking by fraud qualifies for the T. Can I call you around 11 in the morning? You can call anytime. Give us a call. We have our team that answers, does evaluations, attorneys, schedule, the attorneys that work closely with me, go ahead and do the consultations. Can a green card holder who only filed 2 tax returns file for a spouse? This question here depends, right? If you only filed 2 tax returns, were there more tax returns you should have filed that you didn't? That could be a problem. So, but if you only qualify to file 2 tax returns, then that may not be an issue. So definitely get in touch with us. Let's talk and get started. Okay, so the white paper states that the case was held for review, but the officer says expect something in the mail. But it's been 2 weeks now and nothing as yet. So that it seems like they're doing more of an evaluation. So they're evaluating your case, maybe running additional background checks. So and that often happens. They'll tell you, oh, you'll get the decision in a few weeks, and it takes longer. That's not out of the ordinary. Oh, thank you so much, Edward. I appreciate that. How long does it take to get T visa receipt? I have applied 2 months ago, still didn't get receipts. Yes, it's backed up right now. It's not anything strange. Um, all right. Thank you so much for your time. These questions, let me look here on Instagram, just make sure. These are all great questions. And if I could stay up all night and answer your questions, I would, but I want to make sure I have the energy to work tomorrow. So I have to stop. But these are all great questions, and I am going to continue to be here to show up to answer these questions for you. So please go ahead, like, subscribe, follow, hit the notification bell so that when I come on, you'll get notification and others can know that I am here as a resource for information that can empower them. So thanks again, everybody. And just remember that just keep moving forward, keep walking through the fire, keep walking with faith, and focus on solutions. Take action towards solutions. Thank you so much, Tanya. Rest well as well. Thank you. So let's work on solutions. We're here to help. We're a safe space. Get in touch with us so that we can help you. That's our goal. That's our mission. We are on a mission, and we're going to stay steady. Have a good one. Bye bye.